Okay, hello everybody. Welcome to the last but certainly not least panel. However, this is a bit of a contingency plan panel because one of our speakers, Professor Yannick Radi, unfortunately couldn't make it. And one of our other speakers has lost her voice, Professor Gabrielle Marceau. It's really a pity because it's one of the voices you really want to be heard in this context, in the context of WTO law. So I will just very briefly introduce Gabrielle, just so to let everybody know that she's here with us. Professor Gabrielle Marceau is a senior counsel in the research division of the World Trade Secretariat, as well as an associate professor at the University of Geneva. And I think there's actually no one I know better, so experienced in international economic law and WTO law, who has been at the World Trade Organization as of the beginning, and also is a very prolific scholar, next to the fact that Professor Marceau is someone who has done a lot for the international community of scholars in international economic law, both academics and practitioners. So I'm still very happy that you are with us. What we will do is that I will briefly present our other speakers, and then I will try to have a tiny ad hoc presentation that I concocted myself, which can, of course, not at all do justice to what Professor Marceau had said, but at least that we have a WTO element to the discussion. But before I do that, I will introduce our speaker, Thomas-Nektarios Papanastasiou. Unlike Professor Marceau, I only met Thomas yesterday evening, but it's clear to me that this is a man from whom you can learn a lot. For instance, he taught me that the Japanese poet who came up with the word for tsunami, in fact, was of Greek origin. And this indicates to me that this is someone who we can learn from a lot, for sure. So Dr. Thomas-Nektarios Papanastasiou is an associate professor of public international law at the Faculty of Law, Neapolis University Pafos. And he is coordinator of the distance LLM program in international and European business law and director of the legal clinic of the Neapolis University Pafos. He's also a lecturer at the Police Academy of Cyprus, and he has a PhD from Waseda University, the Graduate School of Asian Pacific Studies in Tokyo, Japan. And I think he will talk about a very interesting topic, namely the protection of foreign investments and the concept of territoriality in that. So would you like to maybe go first?
Sure.
Good.
Thank you very much, Anne. Another Greek presentation. I hope we will not sound like my Greek fat wedding, which every word comes from Greek language. Actually, that poet was Lefkadios Hearn, and Lefkada means an island in west part of Greece, if you have visited it. So that's why they call the Japanese as Lefkadios Hearn. Thank you, Anne, for your introduction. I hope I will keep your high expectations for this presentation. And it is quite unfortunate that we don't have the other two speakers. I hope it's not a sabotage to the panel of international economic law. Anyway, I would like, first of all, dear Panos and dear Sotirios, to thank you very much for your invitation. It is really my pleasure and my honor being with you today. So my topic is looks like very specific, but I will try to make it simple enough in order to give you an idea of how international investment law has used some methods of interpretation about a very unique area that also attracts the interest of other fields of international law, which has to do with a procedural requirement, which is jurisdiction and territoriality. And also, I will try to show you some new developments that we are nowadays facing very dense in the field of international investment law. So just briefly, I think Sotirios, we have around 45 minutes for this presentation. No, I'm joking. just to make a very brief idea of what I'm going to talk today, actually, this presentation is separated in two parts. One, which has to do with territoriality. One is a concept introduced by arbitral tribunals, which is more or less like an economic dimension of territoriality. And the other topic is a new development in international investment law, which is the extraterritorial application of this concept of territoriality. So let's make a very brief introduction of what I'm going to talk about you. First of all, the object and purpose of investment treaties is something very important. What we have seen is that in most cases, arbitral tribunals use methods of interpretation that favor the object and purpose of treaties over other rules of interpretation in Articles 31 to 33. Of course, this is a field of public international law. Of course, arbitrators confirm the usage of methods of interpretation in the Vienna Convention and the customary character of these rules. But there are some implications and some particular methods that I would like to show you, which will create some results about how these methods are used in this particular field of international investment law. So I will try to explore how the arbitral tribunals use the object and purpose of international investment treaties, especially in complicated cases where the investment at stake is financial instruments, instruments of non-tangible asset, or cases where the investment is localized in occupied areas. And I will also make some conclusions whether this object and purpose of a treaty has been used correctly according to the Article 31 and not in extension of the obligation of the host state by overriding other rules of interpretation. It is very important issue for us in investment arbitration when we talk about jurisdictional requirements to define what is investment. And in order to define what is an investment that shall be protected by the treaty regime, one of the important requirements of this definition comes within the territorial requirement. And I will explain what is this territorial requirement. But before I go to this definition of investment, most of the bilateral investment treaties, as you know, international investment law is a regime that is constituted by more than 3,000 bilateral investment treaties. But also recently we have a new trend, regional investment instruments signed especially by EU, with some major players like Canada, Japan, China, Vietnam, where we have also free trade agreement chapters, but chapters that include investment provisions. These agreements, as well as the Washington Convention that has created the ICSID institution, the International Settlement for Investment Disputes, have in their preambles a very general purpose, which is the purpose of all bilateral and multilateral investment treaties to protect and promote foreign investments. Along with this purpose, we can see also some other purposes, such as the international cooperation between states in order to support the economic development of the states. By saying that, it is important in order to see how arbitral tribunals have applied this teleological interpretation of the object and purpose of investment treaties. And coming now to the definition of investment, investment protection shall extend only to assets that they qualify as an investment. And what is the qualification of an investment? There are some various factors. One of the most important is the territorial requirement of the investment, which is considered also as a jurisdictional condition. For this reason, we find in investment treaties not only ratione loci jurisdictional clauses, but also ratione materiae jurisdictional clauses, which have to do, as I said, about the definition of what shall be an investment and then a protected investment. So the problem that investment tribunals have faced is not with tangible assets. As you may understand, a traditional investment is a factory or a property which we can all identify the location of this investment, and therefore to finish with this interpretation of the territoriality requirement. The problem exists with non-tangible assets where there is no any physical presence of a financial instrument, of a loan, of a contract, a contractual right, where investment tribunals faced this difficulty, and for this reason, they followed some interpretation methods in order to overcome this problem. So, talking about territorial nexus, which is the link between the investment and the territory of the host state, we can categorize two main approaches that we have seen so far in arbitral practice. The first comes with the name the economic benefit approach, and the second one, the economic unity of the investment approach. And just in a simple way, I will try to introduce you these approaches, which is two methods of interpretation. The first one is related, of course, to various cases that dealt with financial instruments such as promissory notes, bonds, hedging agreements. Famous cases are related to the Argentinian sovereign debt restructuring, the issuance of bonds, where we have claimants against Argentina, and also other several cases. And the important factor for these cases was that in order to establish a territorial requirement of investments with a purely financial nature, we should focus on two issues that arbitral tribunals mention, whether the financial transactions, were made available and utilized for the economic benefit of the host state. So they introduce an interpretation method, which is kind of economic dimension of territoriality in order to support the admission of such claims for non-tangible assets, as I mentioned, the bonds issued by Argentina. However, this way of interpretation created many problems, and of course, lots of critiques by scholars, because in converting the territorial geographical nature of jurisdictional requirement into an economic criterion of the territorial requirement, it seems that it created different results than the actual textual meaning of the investment treaties. So they replaced what has been the most famous wording of BITs, which is an investment shall be made in the territory of the host state with an economic criterion, the economic benefit approach, in order to make an acceptance of the notion of territoriality. And according also to my opinion, that was an overriding of the textual interpretation of Article 31, which was made obviously in order to extend the obligation of the host state towards foreign investors. Let's move now to the second approach. This approach examines what is referred by arbitral tribunals, whether the financial activity at stake is a substantial and non-severable aspect of the overall service, which is provided in the territory of the host state. It seems that this approach stays with the textual meaning, the ordinary meaning of the words, okay, like the Article 31 says, and in order to accept the territoriality requirement, it doesn't circumvent the textual interpretation of territorial clauses, but still it can be adopted for investments of non-physical nature. So what they have said in that approach, the arbitral tribunals, is that even if activities at issue are performed outside the host state, while standing alone cannot be qualified as an investment, they can still be verified as protected investment when there is a substantial and interrelated part of a wider activity which is performed inside the territory of the host state. So that's, for this reason, it is called the economic unity of the investment approach, which made a more matching interpretation of territoriality according to whether the investment at stake is related with the main overall operation, which needs to be inside the territory of the host state. And maybe later I can explain you a little more about these cases and what exactly they did. So there is a big debate nowadays in our field of international investment law. And this debate comes because of a big need. As you may know, we have technological achievements in sense of exploring and exploiting high seas and deep sea bedded areas, especially energy exploration and exploitation, but we face also some legal problems, violation of investment rights, but also legal issues that most of these areas that nowadays high-profile investments are taking place are areas beyond the national jurisdiction, where no sovereign state has any sovereign right. So what it has been discussed so far is whether this economic unity of the investment approach could be applied to cases such as extracting activities in the deep seabed area, where we can involve a kind of such kind of activities operated in the territory outside of the sponsoring state, but in a way that also these activities could be protected by international investment law. Of course, with the condition, according to this interpretation of territoriality, that such activities need to be integrated part of the main project, of the main overall operation, which is taking place inside the territory of the sponsoring state. And this is the newest development of interpretation method that has been applied so far. And I will go a little farther, and I will try to explain you In parallel with what I have done so far with the financial activities, another very important development in international investment law. And I'm talking about the extraterritorial application of bilateral investment treaties. I'm talking about the Crimea example. As you all know, in 2014, it was the Crimea annexation by Russia, and many Ukrainian, especially investors, lost their properties or faced severe damages. So after this incident, we have several arbitral awards that were rendered before especially Permanent Court of Arbitration, tribunals. And while Russia tried to deny the jurisdiction of these tribunals, we have already some awards published, such as the the Swiss Federal Supreme Court, which upheld arbitral tribunals' findings, and especially the hot issue, which was the disputes on the territorial scope of the Ukraine-Russia bilateral investment treaty. And it is important to see how arbitral tribunals made this kind of teleological interpretation for such difficult case in order to show you a method of interpretation of the term territory. So according to the arbitral tribunals, they said that in cases like occupied territories, we go back to the basics. We go to see what is the notion of territory in Article 29 of Vienna Convention. And when the Article 29 mentions that the treaty is binding upon each party for the entire territory, according to the arbitral tribunal's interpretation, this can include also regions over which a contracting state exercises de facto control. So it introduced a new concept for international investment law, which is the control, didn't mention jurisdiction. And moreover than that, it went a little farther, and it used the object and purpose of the bilateral investment treaties in a very evolutionary way, which is the protection of foreign investments. So they said, if we don't accept such kind of extension of application also to areas where a state exercises de facto control, that will create a legal vacuum. It will create a very restrictive interpretation of what should be the purpose of all investment treaties. This is very interesting because I want to apply, because not only me, but also many scholars nowadays, the new development in international investment law because of the Crimea context to many other cases where we have sovereign disputes or territories, areas, maritime zones, disputed maritime zones. And we face this high risk, political risk for foreign investments that are operating in these areas. So one example that I pick up is the example of Cyprus. As you may all know, Turkey disputes the sovereign rights of the Republic of Cyprus. Actually, Turkey is the only country that doesn't recognize Cyprus as a state. And moreover than that, we have faced recently some violations of the exclusive economic zone of Cyprus by Turkish Navy, blocking operations by foreign investors, international oil and energy companies that were licensed by the Republic of Cyprus inside the blocks of the EEZ of Cyprus, and facing, of course, long delays, losses, and also the risk of suspension of their operation. So the fact is that what we are looking now is a territory where, of course, Cyprus has the sovereign right to enforce its laws, but it cannot enforce its laws because obviously the intermission, the blockage by Turkey. So the question is, just I'm trying to show you also what Turkey claims nowadays in Cypriot EES. As you can see, green and red lines are all the region of the Cyprus, actually the whole part of Cyprus Island, which is claimed by Turkey as on its behalf or on behalf of the so-called Turkish Republic of Northern Cyprus. So the case is to see if we have such kind of incident, and following the example of the Crimea context, whether we can use a BIT treaty as a mechanism to review the lawfulness of such kind of actions, especially when the host state cannot exercise any effective control over its territory. And this is, of course, not only Cyprus case, there are many other cases that we face similar examples. So whether we can apply this kind of interpretation, like in the Crimea case, in order to give an extraterritorial application of bilateral investment treaties. I just remind you that one of the problems that we have in public international law in cases of sovereign disputes or violations of sovereign rights is that if we don't have the consent of the other state, we cannot find our dispute, especially in cases like Cyprus, where Cyprus is not recognized by Turkey. We don't have any other legal mean in order to support our case before an international forum. So the point here is that we might have a kind of window of opportunity looking at what is happening in this particular area of public international law, which is international investment law. So there is several objections on this test, on this scenario. One of them, of course, is whether Cyprus case or maritime zones cases are similar to the Crimean case. One big difference is that Crimea is an occupation of land. And we have sovereignty over this land, which was violated by the Russian aggression and annexation. In case of disputed maritime zones, we are talking about sovereign rights, and there is a big dispute whether the Article 29 of the Vienna Convention initially intended to include also other areas which states have no sovereignty, but jurisdictional or functional rights. I'm not going through this discussion, we could do it later, but even if we accept that Article 29 does not extend its application to areas where we have only sovereign rights, modern BIT treaties, like the treaties that we have now between Turkey and many other countries, include in the term of territory also areas of such as maritime zones. Actually, the wording is even more broader. This is a particular article that exists in the Italy-Turkey BIT. It says that territory designates not only the land and the boundaries, but also maritime zones, I underline it, which they have or they could have jurisdiction, the states, it means the contracting states, they have or they could have jurisdictions over sovereign rights. It gives also a kind of potential jurisdiction over areas such as maritime zones, which is quite helpful in order to solve also the problem of what territory means. So I'm going to the end of my presentation. In order to establish jurisdiction of an international investment tribunal, it is important to confirm that like any other international tribunal, also investment tribunals are entitled to assess their jurisdiction and determine by themselves whether the investment in question has been made in the territory of the host state. So using the example of Crimea, we have a new development. The investment tribunals accepted that in order to assess whether they have jurisdiction or not, they determine the notion of territory as also areas where Another state is controlling, is exercising effective control. And not only this, talking about the unity of public international law, we are not a different section of our legal science. We belong in the public international law. It is important to mention that in the reasoning of the investment tribunal's decision about the territory, they mention several cases of other international mechanisms and courts, such as cases from the jurisprudence of the ICJ and especially from the European Court of Human Rights, which is, as you may know, very rich in explaining the notion of what is effective control. And we have several cases. Yesterday, I think we heard from Professor Pinto, former judge of European Court of Human Rights, how the effective role and this interpretation has played a very significant role for extending the application of the Human Rights Treaty over several cases, happen to be also in Cyprus, in occupied areas. And just in conclusion, the economic approach interpretation of territoriality seems that was used in a different methodology than the one which is supported by Article 31, as it disconnected the notion of protected investments from the territorial requirement. On the other hand, the economic unity of the investment approach follow a more correct, I will say, requirement of territoriality between financial transactions and specific investments or projects that are operated or performed inside the territory of the host state. And in conclusion, I stressed out that also the case of Crimea, we should not underestimate it. As I mentioned, it is the first time that an arbitral tribunal has found the BIT, an investment treaty, to be applicable in a territory which is regarded as an illegally occupied territory by international law. And maybe we can see such kind of pragmatic teleological approach happening in more other cases in the future. Thank you so much.
Thank you, Thomas. I think this is very fascinating. And if I understand it correctly, this might sometimes mean that parties may use two different BITs to apply to the same territory. Namely, if in the case of Crimea, you could have the Russian BIT applying to maybe Ukrainian investors, but also maybe the Ukrainian BIT for non-Ukrainian investors.
Sure.
And the same might be the case for Cyprus, with Cyprus BITs and Turkish BITs. So that is, I think, we are really in a crossroads with this in this regard, and with international investment law, and many interesting questions. Also some parallels, I think, with international trade and trade with occupied areas. If you think, for instance, of the Western Sahara and how the EU extended its application of the EU-Morocco free trade agreement to Western Sahara, which was, of course, also highly criticized. But I see a lot of parallels and a lot of interesting things. So, not to completely omit the WTO, I have a small improvised presentation on interpretation, rules of interpretation in the WTO. Now, let me first say that I personally, of course, am of the opinion that World Trade Organization law is the most interesting area of public international law. I'm not at all biased. Of course, it's famous for being labeled a self-contained regime. And it has to be said that although the appellate body right now is unable to hear cases, the World Trade Organization two-step dispute settlement mechanism really has been unusually successful in the area of public international law. First of all, because of the compulsory jurisdiction of dispute settlement of WTO members of their cases, and the two-step nature, and the fact that because for a long time it was considered a maybe less political and more technical area of public international law, parties were really quite happy to settle their disputes there. And until recently, almost more than 600 disputes have been heard by the dispute settlement body. So I do think that although the WTO system is under strain, you can definitely say that it has been a very fruitful area of public international law and dispute settlement, and it would be a great pity if it wasn't so going forward. But we will see. We will see. All right. So when we talk about what the dispute settlement understanding says, it says in Article 3.2 and Article 19.2 that the dispute settlement body, panels, and appellate body cannot add or diminish the rights and obligations provided in the covered agreements. So this means that while, of course, in the same article, it says that general rules of that it is a duty to clarify existing provisions of those agreements in accordance with customary international rules of interpretation of customary international law, is of course a balance of where the panels and the appellate body can go. And this has of course also been criticized and might be one of the reasons for the current political impasse there. In the US gasoline case, the appellate body has said that general rules of interpretation have indeed attained a customary international status, and it contained in Article 31 of the Vienna Convention. And in Japan, alcoholic beverages, it was also determined that Article 32 has attained that customary international status. So it means that there has been great development with regard to WTO law and the interpretation of certain provisions. And I would like to give you some examples. So if we look at the WTO exceptions in Article 20, the general exceptions, there is an interesting example, for instance, with regard to Article 20J. This is an exception that allows members to take measures essential to the acquisition or distribution of products in general or local short supply. And this exception was litigated for the first time in the India solar cells case between the US and India. India tried to make the argument that it had to have local content requirements with regard to the production and distribution of solar cells because they were in local short supply. And the appellate body had to interpret this provision to determine whether it could be used, this exception could indeed be used for products in local short supply. And it was very interesting to see that the appellate body said that while the provision that was drafted after, in the 1950s, after the war, and it was usually meant for emergencies and natural disasters, it could indeed be used and interpreted in today's landscape to also take into account global shortages of the product and product markets. Also, interestingly enough, India tried to use this exception to litigate a future local shortage, while the appellate body said, no, it's important that it's actually a current shortage, but you can look at global markets. So that really does show a interpretation that has evolved. Now, another and of course famous example of how WTO law has developed in this case is with regard to the famous exception in Article 20G that is necessary to relating to the conservation of exhaustible natural resources. A famous case is the US shrimp turtle case, where the panel and appellate body had to look into whether turtles could be seen as an exhaustible natural resource. And the appellate body said that while, of course, exhaustible natural resources were drafted, the articles drafted to have non-mineral resources in mind, this could also be extended to livable organisms. So it was also important to see and consider livable organisms as finite. They were saying it's been drafted more than 50 years ago, and it's very important that contemporary concerns of the community, such as protection of the environment, are taken into account. So protection of the environment and also extending the idea of exhaustible natural resources to living organisms is a way of dynamic rather than static interpretation, and shows an evolutionary approach towards WTO law. Another recent, relatively recent example is the interpretation of necessary to protect public morals in Article 20A, to include, for instance, issues of animal welfare. So the EU was very concerned about animal welfare, in this case, the protection of seals. And the appellate body indeed said animal welfare is a legitimate public moral that can be placed into this article. Last but not least, I want to mention something that's, of course, highly relevant today, and that is the Pandoras Box national security exception in Article 21b, subparagraph 3, which was litigated for the first time in the case between Ukraine and Russia in Russia traffic in transit. This is an interesting case because Russia was blocking imports for Ukraine and then invoking the national security exception, saying that there was an international emergency and it had to take this. I will just read the article because it's interesting. So it says that nothing in this agreement shall be construed to prevent any contracting party from taking any action which it considers necessary for the protection of its essential security interests taken in time of war or other emergency in international relations. So the question was to what extent this article is self-judging and to what extent Russia could invoke this article successfully. And the panel in this case actually went into the negotiating history of the article to try and determine what a time of emergency in international relations was and what kind of essential security interest it considers to be essential in this case. It was interesting because they went back to the drafting of the article and they really had to balance between determining that it was also up to GATT parties, WTO members to determine what their essential security interests were in the first place, also what actions they could legitimize under this article. So you have to have an article that really does cover essential security interests, but does also prevent abuse of this article. So it was really a balance that the panel in this case had to strike. So it went about the case in the sense that it did judge that Russia could invoke. There was indeed an emergency in international relations, but that the article wasn't completely self-judging in the end. Where we stand today is, of course, a different place because some WTO members, some prominent WTO members, are of the opinion that the appellate body has been acting in overreach. And this is one of the causes, you could say, that the appellate body is unable to hear cases right now, as new AB judges have not been appointed. The bigger question is whether the appellate body will ever be able to use Article 31 and 32 of the Vienna Convention ever again, in the sense that will they ever hear cases again? And if they don't, will we see these rules of interpretation used in the MPIA, so the multi-party agreement that has been established by 27 WTO members that can hear cases amongst themselves in the time of appellate body impasse. So while there has been a rich use of interpretation and development and quite a dynamic interpretation of WTO rules in WTO dispute settlement, I think the big question is where it's going now, where is it going forward? And I think only time will tell. So thank you very much. Thanks. Okay, so I think we can open it up for questions. And I assume, right? I think Sotirios and Panos, unless you want to add something, we can direct questions as from the last panel. So last chances to.
Yeah, hi again. Thank you very much for this very interesting presentations. I have one question for Thomas and one question for Anna. So I'm going to start with a question for Thomas. I actually have a lot of different things that I would like to discuss further. This was a very fascinating topic. I'm just going to press on the issue of whether and to what extent it is actually appropriate to use the jurisprudence of, for example, the European Court of Human Rights in the context of determining issues of jurisdiction in occupied territories in investment arbitration. I know that this is an argument that has been made several times. There are some criticisms as to the scope of jurisdiction in the two different regimes. I would just like to pick your brain on this issue. And for Anna, thank you so much for this last-minute presentation, which still managed to cover pretty much most of the controversial issues, especially in the context of exceptions. And I'm just wondering what you think of the interpretation of the panel on the national security exceptions, because I know you mentioned that they had to strike a balance, but their report actually reminds me of Antonius's rant yesterday about kind of using, you have specific guidance under Article 31 and 32, but then there's a very large kind of margin of appreciation for the judge to use this as they deem appropriate. And I think in this case, it was a case of having very scarce evidence as to what really the parties meant when they said it considers necessary. And then we went for a very, very lenient approach, saying that necessary is something that is not implausible, which I'm not entirely sure that it results from any of the materials that they had in front of them. So do you think that this adequately balances the competing interests in this case? And is this an interpretation that must really be followed from future panels, or perhaps an appellate body or appellate body-like adjudicative body in the WTO? Thank you very much again.
Thank you, and thank you to the panel, to both speakers, and particularly Anna, well done on an improvised presentation. I have two questions that go to the presentation of Thomas, which I found interesting in the sense that it was quite wide and draw my attention to a number of issues. A number of issues I wanted to comment on. Essentially, two issues. You briefly touched on areas beyond national jurisdiction, and I felt it was a bit brief and a bit short. What I didn't quite get in your presentation is, where does this fit in with the advisory opinion of the Seabeds Dispute Chamber on the relationship, the jurisdiction of the sponsoring state over the work of the contractor that is licensed to undertake at the moment exploration work in the deep seabed, but in future the exploitation work as well. I think that in that advisory opinion, it was quite clear that what is to be expected from the sponsoring state is that it establishes jurisdiction over what the contractor does, not just we can take out an insurance. No, you have to be in control of that mining company. That was, well, it was a much applauded advisory opinion. It clarified something, but it now seems, at least that is how I understood you, that you're questioning whether this notion of economic unity of the investment is enough to ensure that there is jurisdiction. Well, if it is not enough, you end up in a black spot, which is exactly what the advisory opinion sought to prevent. So maybe you could comment a little bit more on that. As to the other and more extensive part of your presentation, how investment protection works in times of occupation, and your final comment was about the importance of the unity of international law. It seems to me that in the situation in which you described with respect to investments in Korea, that the way in which case law developed, it developed in a direction that is absolutely contrary to the law of occupation. Rule 1 of occupation is that the occupying state may not rely on its own legislation for matters taking place in occupied territory. Now, I do see a problem from the perspective of investment protection, because, of course, it's a bit difficult for the occupied state to ensure the implementation of its own law its own law and its own treaty obligations on investment protection. But then to say that it is for the occupying state's law to apply runs directly against the text of the Hague regulations. So yes, it may be solving a problem of investment protection, but it's not very good for the unity of international law. The rules of the law of occupation are there for a reason. It's not as though the occupying state can come and say, oh, well, from now on, we are applying my law. That is exactly what the Hague regulations prohibit. So it might be that I'm just struggling with the latter issue. So far, I don't think it fits properly, irrespective of what the Swiss Federal Court has said. I'm still a bit troubled by that.
Shall we do a first round of
Sure.
answers? Go ahead.
Thank you for the questions. I hope I will address your very interesting questions and issues that you have raised. Let's start with Anna. Whether using jurisprudence of another international court, like the European Court of Human Rights, is a legitimized issue for the investment tribunals in determining issues of jurisdiction. The problem that we have faced in international investment law is the opposite one, the fragmentation, not using any of the concepts or principles of the general public international law or of other sections like the European, the human rights law. What they have done is revolutionary in the way that they did this, is to explain that some rules of international law that are applicable to the states, both states that time were part of European Court of Human Rights, European Convention of Human Rights, we can use them in order to facilitate the interpretation of issues that are similar in the way that they have been applied in other cases in other courts. And it is similar because when we talk about protection of investment, we are talking about properties. We are talking about the right to property, which is also a very central issue of the European Convention of Human Rights. So I guess that this was a good example of facing the challenge of fragmentation that we have seen from other cases in the issue of determination of jurisdiction, especially when I talk about the interpretation of what is effective control. Again, this is a principle that has been used by many other courts, and it is useful for investment tribunals also in the context of Crimea. So I'm going now to your questions. Of course, I really feel your anxiety of having a kind of result that is going in contradiction with main principles of public international law. What is important to state about the legality issue of, let's say, annexation? First of all, investment tribunals try to escape, I agree with you, from issues of sovereignty or of legality of the actions that have been in concern, like the actions of Russia, by going in the light of the object and purpose of the treaty itself and saying that by definition, our goal, our purpose is not to deal with sovereign disputes, with matters of delimitation. These are issues of a very different scope of application of other instruments, international instruments, such as the International Law of the Sea or International Court of Justice. In the light of the object and purpose of the international investment law, our main goal is to look at how we can secure the purpose of protection of foreign investments. However, this does not mean that an illegal action, an action of use of force, is recognized or accepted by the decisions of investment tribunals. On the contrary, I will say, in order to establish jurisdiction, it took as a fact not whether the occupying state law will be applied. It didn't make any conclusion about this, but it took only the fact of whether there is a link between the exercise of the effective control between that contracting state and the investment at stake. So this was the only concern that it needed in order to establish the territorial requirement between the actions of that state and the investment that was the important goal to secure its protection. I think this was only a way to facilitate the extension of the application of the treaty in the sense of determining what is effective control of the occupying state. And issues beyond, about areas beyond national jurisdiction, yes. If we talk about the deep seabed activities, we have to deal first about the advisory committee of the deep seabed organization. It cannot. I didn't propose that such a theory of interpretation like the economic unity of the investment approach will replace the jurisdiction of the advisory committee. I'm just referring this as a supplementary issue when it comes to substantial provisions of protection of foreign investments, which are not included in the way the advisory committee, I guess, you may correct me, but in the sense of the specification of the provisions that are included in investment treaties, I guess there might be some differences. So, of course, in terms of jurisdiction, it cannot replace it, but as a parallel proceeding, it might be a possibility to start also an investment arbitration, considering the substantial provisions of the treatments that are included in investment treaties. However, this is not an example that we only focus. There is also other cases like overseas high seas investments. I'm mentioning about a very real pragmatic scenario about construction of pipelines and cables, when we have now issues in Europe and in other places of the world where there is an investment which is located in a host state creating a pipeline, but this pipeline goes somewhere else. There is a transboundary characteristic of this project, and when something happens to areas beyond national jurisdiction, it will create a problem if we cannot secure the protection of the foreign contractors that work for this pipeline, if we accept that there is no any link with the sponsoring state, with the host state that was initially started the project and initiated this investment. So there are many other cases that we can look beyond the national jurisdiction, which there is no any solid legal background, like in the case that you mentioned for the deep seabed organization. Last, I think, Anna, you mentioned about whether we can use in the beginning of your introduction also a claimant against Cyprus based on a Cyprus BIT treaty. Yes, this is also one scenario. However, in order to do this, we should be the investor, I mean, should have a problem in order to establish the causality link between the action and the damage of its investment. And in this case, it is not the host state, the original host state that has created the problem with the foreign investors. It is another state which has intervened.
So I do, on the one hand, understand that the panel had to tread very carefully, also because especially the US and Russia, and as well as other big, important WTO members would say it's a self-judging article. So it had to really, for this first time that it was litigated, it had to really tread a fine balance between what was possible and allowing WTO members, their space to define their own security interest, while at the same time not leaving it completely open for interpretation by members itself. So in practice, what did that mean? It meant that it established that there was an emergency in international relations and that therefore Russia could invoke successfully Article 21. In practice, this has other implications, because what does it mean in practice? In practice, it means that one WTO member can start a war because it didn't further research who was responsible for the emergency in international relations, right? So you can start a war, then block imports from the country you're waging a war against, and then successfully invoke Article 21 B3, which is in the real world, while legally understandable, in the real world quite problematic, because it first of all allows, in a way, unilateral sanctions under the WTO from one member to another, and it also is the principle of ex injuria jus non uritur. So you shall not create justice by doing injustice. So you can start waging a war and then, invoke successfully Article 21 of the GATT. Is that a world we want to live in? Yeah. So these are, I would say, I understand completely the legal reasoning. The realities that it creates are paradoxical and not easily to be solved. So I don't know if it answers your question at all, but it gives you at least some insights into this. So are there any other questions? Yes. Please.
If I may follow up on that, because of the ex injuria jus non uritur, but directed towards Thomas's scenario in the Crimea. Because I'm kind of struggling with the factual scenario. I don't know the arbitral award, of course. So I could imagine, of course, Ukraine with a Ukrainian company investing in Crimea, but that would be in the territory of Ukraine, so wouldn't raise any Ukraine-Russian issues. You can go the other way. A Russian company investing in Crimea couldn't, of course, make a claim against Russia, because, of course, Russia claims Crimea as its own territory. But then the third scenario would be a Russian company making a claim against Ukraine for an investment in Crimea. But then, of course, the ex injuria jus non uritur kind of comes in, because a Russian company will be invoking a right derived from the bid in relation to an unlawful act of its own country. So I'm kind of wondering how the issue of territory came in, because of course, you could also say, I understand they said territory also means territory under de facto control. But how is that possible in a bilateral treaty when, the other party to the treaty actually has lawful sovereignty over the territory? So I don't see how you can favor de facto control of Russia as an illegal occupation over the lawful title which Ukraine has over its own territory. So I was kind of wondering what the factual scenario was, which company against which state, and where, I assume with an investment in Crimea, but how exactly? No, the other possibility is, of course, BITs with third states, and then the question, against who are you going to claim? I understand that, but I don't see how the Russian-Ukrainian BIT comes in that way.
That's why sorry, is it okay?
Of course, I think this is.
Yes, Andrea, this is the question, and this is what I said. It's a very huge development in international investment law. What is happening after this precedents? The point is that the arbitral tribunal played with the notion of territory in a very sensitive way by explaining that this notion should not have only a territorial character, but it has to deal in our section, in our sector of international law, the investments. It has to do also with the functional character of what is a territory. And the functional character of the territory for the purpose of applying in international investment treaties cannot only be linked with a geographical notion of an area, territory, or a maritime zone belonging to the sovereignty of a state, but it has to do also with how this area is interfacing with the investment at stake. So by doing that, might be a little philosophical, but this is a very hot topic now in also other areas of international law, how we are talking about a transbounding concept of territory, because we have to deal with also global governance issues in international law, not only issues that traditionally we deal with the classical geographical character of territory. So what it stated is that if I do a restrictive interpretation, according to what you said, and realize that this is not a territory of Russia, and then this is a territory that I cannot establish, I cannot enforce the national laws of the original host state, which is Ukraine, then we will leave the foreign investments that were violated in a vacuum, because we will say that, of course, I recognize that the violation came from Russia, but Russia is not considered as the host state of the particular case. The host state is Ukraine, but Ukraine cannot enforce its laws because it has lost its control. So we will keep the situation as without any result. And this is what it came and said, that by determining territory only in its functional way, by saying that I will use the effective control approach in order to make a teleological interpretation, and using this interpretation to support the purpose of the treaty, which is to protect the investment, it concluded to this result. And if I may say, this is not new in international law. I mean, what the European Court of Human Rights have done so far with all the occasions of occupied territories. I mean, it started with Cyprus, with Titina Loizidou case, where it agreed that this is not a territory recognized as a territory of Turkey, but I have to recognize that the presence of military and administration by a country is equal to what it says for first time, exercise of effective control. And I have to mention that from this case started the extension of application of human rights also to areas of territory. And of course, this was traditionally done by international humanitarian law, but in terms of investment, we see for decades now a kind of replacement when it comes to protection of property in terms of how international investment law is applied to such kind of cases, which is new now because of the Crimean precedents, but it's something that we are waiting to see how it will be developed. I suppose yes, but if a Russian investor has been violated today, it is his own government that he should. But Ukraine. But we have to see per se every investment whether there has been a violation of the state that it is involved. So if the Russian investor, let's say, suppose that he's claiming a damage suffered by Ukrainian government, of course, we have to see the causality link. We have to see the facts. In what sense it was damaged, which is something like a scenario impossible for the moment. At the moment, there are 14 cases, and we have already 10 cases rendered by the Permanent Court of Arbitration. And it is important to mention that in the first cases, Russia avoided to take part in the procedures by saying that I don't recognize any recognition of these arbitration tribunals. We have already several millions of compensation rendered for the first cases, and now the Ministry of Justice of Russia has announced that we are changing our strategy, and we will also participate in this investment arbitration procedures. It's really hot topic. It's ongoing, and we see, personally, I see a great development, either positive or negative. We will talk about this later, but this is what we call we need to have sometimes to see the national law if it has teeth to bite and to create some enforcement. Okay, in the case of Ukraine, it's the only one case, I mean, the arbitration awards, that we have seen international law putting pressure in a legal matter to Russia because of the Russian annexation in Crimea. So far, it's interesting to see that, but I hope we will see more next year, maybe when Panos will do the next round of TRICI conference.
So going to Panos, I understand that this is our last question. So you as the conference organizer, of course, please go ahead.
Thank you, Anna, and sorry for that. It was just piggybacking on your discussion about Article 21. And again, let me preface this. I have no idea. I had to quickly download Article 21 to look at the text, what it says. So because you mentioned that there could be a possibility of, you being the aggressor, and then invoking, 21B3, that you can take measures and then you're scot-free. Don't you think, however, that it would be possible for an arbitral tribunal to kind of say, well, we need to read Article 21, that such a reading would lead to an absurd result, that this is essentially an abuse of rights, and therefore, taken in time of war, there is an implicit implication that you are not clearly the aggressor. And the reason I'm thinking this is because a similar discussion, for instance, happened with Article 60 in the Vienna Convention on the Law of Treaties on material breach. The text itself says who can invoke material breach, but it has a list, and it does not specifically mention the state that has materially breached the treaty. And there was a discussion in Croatia versus Slovenia about, well, can we read that into, because other grounds like fundamental change of circumstances clearly say if you are the one responsible for the situation, you cannot invoke it. And they basically said, yes, naturally, we can read it. So I was wondering if there was anything in the preparatory work in Article 21 that says, well, we don't care.
Yeah, I don't know about that, but I can definitely say that, you know, if you ask, let's say, me as a human, I would say, of course, do that. That's the way to go. That's the only right way to go. It's absurd that you can invoke Article 21 following, let's say, a war that you start yourself. On the other hand, it is, of course, a very political matter, and I cannot, and international, it's a member-driven organization. I have to say member-driven organization. So, of course, there's also the risk if a panel would go very far into looking who was responsible for a particular violation, that you would have members saying, oh, if you aren't going that far, we might well withdraw from the WTO altogether. So, and I don't dare to say with certainty that, but that I can realistically imagine that might have happened behind the scenes. I'm not sure, but if you ask me as a human being, justice, etc., I would say yes, of course. Legally, politically, perhaps we can see it develop that way. It would be great if it could. But yeah. Oh, okay, sorry, I forgot I'm the chair. So if you don't mind, I think this was our contingency plan panel, our emergency panel. I think we still managed to have some very interesting presentations and
Thanks to the
discussions
questions from
and
the
questions from so.
was a challenge on us, but
Still
good.
paying attention after a full 2 days of conferencing. So thank you so much, everybody, for participating and listening and asking your questions. Thanks.
Falls to me the task of summarizing what we did this last 2 days. I will try to be very brief. So, and very vague too, because it was a quite diverse conference. But I will try to flesh out the common themes. And for me, these themes were also areas of contestation sometimes. We had some debates, always civil. But so from what I understand, the claim that there are rules of interpretation and they do something is at least, you know, agreeable today. But what exactly do they do is what I think lies at the very crucial of the discussions. One of the things that I think went uncontested was that rules of interpretation tend to enable actors to participate in a way in the development and the determination of law. So we've heard from Ellen about how the ICRC has contributed to the interpretation of treaties, essentially making sure through and taking advantage maybe of its institutional role according to those treaties. We've heard from Melissa Morgera about the role of stakeholders to shape law also through making use of rules of interpretation of and they in that way shape international environmental law or international law of the sea, and so on. But they also tend to have an entrenching function as well, as far as the other issue that this conference raised, the issue of unity, diversity, and evolution. So if a court has a rule of interpretation, this is a foothold to say, oh, I have my own rule of interpretation, by the way. And I think we touched upon a little bit on that when we talk about the ICC and also about the WTO. I think Anna started with the statement that it is a self-contained regime. Deal with that. So this is the first function, I would say. The other two functions, I think we can also agree or disagree. I think we enter into the more contested area is that rules of interpretation can have a systemic function and a evolutive function, that they tend to help in situations of intersection between different strands of law or perceived as different. I won't explain that. And also they tend to help with respect to claims for transformative change, call it whatever, and for development of the law, call it whatever. It is a way in which, interpreters tend to use these rules. Now, the most contested issue was whether they have a legitimizing function. So, is it the whole situation with the cook, are judges cooks, and the likes? But at the very least, they give the veneer of legitimacy to those who have the power to use it. It's not raw, they don't apply law by brute force. Usually they reason their judgments, and we can see that there is a common terminology to do that. Now, we also had some discussions about the technical and the nitty-gritty of the claim that we also have made, that customary international law can be interpreted according to rules of international law. Now, I won't go into that. The only thing I would like to do is to clarify two things. To a very large extent, the idea of custom as this amorphous thing, I think, does not correspond to practice. It is always some kind of text. We come up with a text and we interpret this text, right? So the whole idea of it is essentially identifying that text and then trying to figure out what kind of methods we are going to use in order to resolve the interpretative problems that arise from the use of this text qua customary international law. And from then goes the whole situation about normativity, ruleness. We can disagree on that. So on that note, I would like to thank everybody for being here. I would like to thank Tatiana so much for doing everything. Nina, Marina, Conrad, who cannot be with us now, and to give it to Panos for the rest of it. Thank you.
Thank you very much, Sotirios, for this very beautiful summing up. Just to add to your final point, and again, in the context of our aggressive marketing, that customary international law is not really amorphous, that there is a version that is in our mind. I think Denis Alain said it best in one of his Recueil de Cours courses, where he said that basically every rule, even the unwritten ones, have un vêtement lexique, so a lexical garment on which we kind of refer to it. And I think this kind of shows that no matter how unwritten it is, there is always a representation that we have, that we may have found it somewhere, or at least is in our mind, because that's how humans, Anna, work. Again, as Sotirios said, I'd like to thank our TRICI-Law team. We've already named them quite a few times. Of course, our keynote speaker, our chairs, our speakers, both present and online, and of course, the audience members, with a special shout out to our cohort from Groningen who took their time and came to support the conference. So thank you all very much. We know and appreciate how difficult it is with everybody's busy schedule to carve out 2 days for a live conference. But we do appreciate the live interaction. We've very much brutally missed it during the COVID period, and we've hope that this will be one of the many occasions to see familiar and new faces again and again, and continue our discussions. As a matter of housekeeping, we will act, I'm going to say again, as not as academics, but as human beings. So we know that the holidays are almost upon us. So we will refrain from pestering you about possibilities of publication from this conference. conference. We will let the holiday cheer go on, and after the holidays, then we will come back with a vengeance. So beware of the emails. Make sure to block us. The idea is that we intend to publish the proceedings in the form of an edited volume with Cambridge University Press, which is going to be open access. Of course, our speakers will receive an email, but of course, the chairs as well, or if they're interested, willing, have the time, many caveats, more than welcome, and we'll send you then the information about the classical style type, and then we will start hunting you down for the provision for the chapters. On that beautiful note of hunting down, thank you again all very much for being here, for engaging in this lively conversation, and I hope we'll continue this discussion for a long time. Thank you very much.